All right. At this point, let's go over the victim impact motion.
Yes, Your Honor. Just very briefly, I know the court has reviewed defense's motion and understands that our argument is in regards to the potential inflammatory nature of victim impact statements in general, and how the potential inflammatory nature of it will not allow Mr. Amato to have a fair sentencing proceeding.
Let me ask you, the concern in regards to the victim's impact statement, are you concerned with just the aspect of the victim even speaking, or the fact of what might possibly be said if they are allowed to speak, that they might go outside the aspect of the aggravating factors?
Well, first, we would argue that that information, what is in the victim impact statement, we have received a copy of what will be said from the state. What we were arguing is that the victim impact statement itself would be better in front of Your Honor rather than the jury. As Your Honor understands, the jurors are here to determine aggravating and mitigating circumstances. Your Honor will instruct them to only consider aggravating and mitigating circumstances. The victim impact statement itself does not go to that, and because of that, Your Honor, we'd ask that the victim impact statement is better in front of Your Honor than the jury. If Your Honor is to find that the victim impact statement itself is admissible in front of the jury, there is a particular aspect of it. I don't know if Your Honor has a copy that I want to review with the court.
If one was filed, then it was not sent to me. Because the court, I can tell you, the court's more inclined and that's why I was asking what your concern was, to have the statements, possibly a statement read, but not where it'd be a question and answer type circumstance by Mr. Stone as to the circumstances. That's where I'm more inclined to go, because my concern would be if there's other aspects that would be going outside what would be considered for the aggravating factors. So I don't have a copy and I don't see a copy filed. Was there victim impact statements that were?
No, we just received it late last week, and there's actually, did you get the one that I sent this morning, a revised?
Yes,
although
sir.
I think it's.
Yes, sir, that's the one that Mr.
That's the revised one?
This is a revised copy, if I may approach Your Honor.
You may.
This is from Jason Amato, Your Honor.
And just to say, I'm referencing the last paragraph on page 3 of the prepared impact statement. I imagine, I'm not sure, but I imagine the state intends to have Mr. Jason Amato read off of that and not anything else. I don't know if that was the intention.
I think so. Yes.
And we understand the case law is very specific as to what is able to be brought up in an impact statement, Your Honor. The issue that we have is, and while we're very sympathetic to Jason's loss of his family here, there is a mention made of the loss of his girlfriend's father that I do not think would be admissible in this particular trial, Your Honor. It doesn't go to the loss in the community.
Understood.
Yeah.
Mr. Stone, you got a response for that one?
Well, I don't have a problem if we highlight the portion that they're concerned with regarding the loss of Christina's father, and delete that from the statement.
And
One moment.
I'm sorry.
Let me finish reading it real briefly. All right, so the second sentence on the third paragraph, the entire sentence, the court would indicate shouldn't be read. On that on third page, I'm sorry, second paragraph, where it says added to the loss of my family.
Yes, I highlighted that portion, yes, Your Honor.
And Your Honor, how about the next sentence, too many tragedies for anyone to handle?
Well, with all due respect, I think that can be interpreted as to these
Yes, Your Honor.
3 individuals.
And again, Your Honor, we would just stand on our previous argument that because, and having reviewed the rest of the impact statement, it does seem to comply with what the Florida statute 921.1417 would entail for victim impact statement. We would just stand on our argument that this victim impact statement would be more appropriate in front of Your Honor rather than the jury.
Understood. What I'm going to ask, and Mr. Stone, besides Mr. Amato, my understanding there were two other impacts. Are the impact statements also given on those?
Well, with regard to Christopher Cisco, we're just planning on putting up his testimony, and I've already spoken with him.
I'd like to then, otherwise, I would prefer it either be written or somehow indicated, so that way there's a parameter to make sure of where he's going.
I discussed with him the parameters, Your Honor. The statute, I'm referring to 921.141, subsection 8, clearly gives the prosecution the right to present victim impact evidence. Evidence can be either written or in the form of testimony.
I understand,
in front
Mr.
of the jury.
I understand, Mr. Stone, and the court also has the ability to set the parameters if the court would choose for it to be written rather than questioned.
He hasn't written a statement, Your Honor.
Well, I may have him proffer it then prior to us starting.
Of course, that's acceptable. My understanding is that
And who's the third?
Sloan Young, and I've just been informed that she wrote a statement. I haven't seen it yet.
Okay.
So I literally just moments ago, so I'll look at it and I'll make a
Well,
copy.
where is Ms. Young here?
Mr. Leo is getting it right now.
All right, if he could make extra copies for the court. And then otherwise, as to Mr. Cisco, where do you anticipate going as to that one?
Well, I'm just going to simply ask him 3 or 4 questions, just basically.
And that's what I'm asking, Mr. Stone, what are the 3 or 4 questions, or what questions are you asking him?
Well, I was about to tell the court, the 3 or 4 questions is basically his name, where he lives, his occupation. Did he know Jason, did he know?
Cody Amato?
Cody Amato. How long did he know them? How did he know them? His relationship with them? And then the last question is just, and then I'm going to ask him to describe what kind of person Cody Amato was. And then the very last question is to describe the impact on him and the hospital community of Cody Amato's loss.
All right. The first 4 are clear from the trial. 1, 2, 3, 4, 5. So all of those, the name, where he lives, occupation, Cody Amato, and how long. However, the relationship in describing him as a person and the impact on the community and the hospital, the court hasn't, those would have to be proffered prior to him testifying. Okay? And then we can go from there to make sure that where the parameters are going.
And, Your Honor, will the court instruct the jury that the victim impact statement is not considered evidence?
I can. It is something, though, that they are able to consider for the basis for the circumstances of its testimony and their statement for them to consider according to the aggravating factors.
Understood, Your Honor. The issue is I'm not sure that the loss of these, the Amatos to the community, I'm not sure that it goes to any of the aggravating circumstances that, aggravating factors that the state would be arguing.
Okay.
So we have an issue where we're having victim impact statements.
When was the notice filed? What was that?
What? I'm sorry?
For the notice for that, what aggravating factors, so I can go back and look at it again?
The 2 aggravating factors that we're alleging and that we noticed are code calculated and premeditated.
And then heinous, atrocious, and cruel?
No, and the prior convictions for a capital felony.
Okay.
And with regard to the victim impact evidence, part of the standard instructions to the jury is that they're not considered as aggravating circumstances. So the court's going to instruct the jury on that.
Do you all have, and I noted the jury instructions, that's the other thing. Did you all just look at both the jury instructions at that point? I know we're going to go over those during lunchtime, but just to see where we're at.
And Your Honor, with regard to Sloan Young, I've just been informed that there is no written statement. She may have made some entries in a journal, but as with Christopher Cisco, I'd have to proffer her testimony, and I would probably need to speak with her beforehand hadn't had a chance to do so this morning, just to make sure she knows what she's limited to.
All right. Let me see. Well, I would like to, what we're going to do is we're going to have Chris Cisco come in and we're going to proffer his testimony, and then we'll take a recess. You can talk with Sloan Young, and we'll go from there. The aspect of the jury instructions, just for the defense, did you guys have an opportunity to look over the jury instructions?
I'm reviewing it now. Mr. Lyko handed me a copy, Your Honor. And just after just a quick review, I haven't had the chance to look through everything, but on the first page, second full paragraph, there are the 5 factors that the jurors will be instructed on, and not included there is victim impact statements. They'll be deciding on aggravating and mitigating factors, and a victim impact statement does not qualify as what they're to consider. Again, I haven't reviewed the entire document, so I'm not sure if it's elsewhere.
It's in there. I'm not sure if it's in the initial or it's in the final instructions, but it's in there. It's actually on in the final instructions on the top of the second page. First paragraph.
Right.
Can you provide me your instructions? I just want to make sure I'm looking at the same thing that you have.
Yes, I emailed them out on
4:45,
Thursday.
yeah, I'm looking, where are you, I'm trying to figure out where you're looking, and maybe it's just the
What I
way.
emailed to the court were the preliminary instructions in the capital cases, that's 2
Right.
pages.
That's what I have.
Then in that email, there's another document, final instructions in penalty proceedings,
I didn't get-
capital cases.
I don't know why, but I don't have the final, I just have the preliminary. So can you get me, oh, there it is. Okay.
And it's on the top of the second page.
So I had the preliminary printed out. Okay. All right. Okay, so it's in the final instructions, not in the beginning instructions. All right, at this point, let's get Christopher Cisco in here. Mr. Cisco, come forward, please, sir. Raise your right hand, be ready to be sworn.
Yes.
All right, if you could have a seat. Essentially, sir, what I'd like to hear is what your testimony is going to be before you actually do it before the jury. All right, so if you could have a seat, Mr. Stone's going to ask you some questions. And then we're going to go from there.
Thank you.
You may proceed.
Thank you. Good morning, Mr. Cisco. How are you?
Good morning, good.
Just tell us your name, please.
Chris Cisco.
And where do you live, Mr. Cisco? And once again, as we did in the first part, whatever you feel comfortable with, city, town, county.
Orlando, Florida.
And what do you do for an occupation?
I'm a certified registered nurse anesthetist.
Now, did you know Cody Amato during his lifetime?
Yes, I did.
And tell the court, please, how did you know Cody Amato? Just tell us how long you've known him and describe your relationship with Cody Amato.
So I've known Cody for roughly about 4 or 5 years. I met him first in anesthesia school for CRNA, and then we graduated together and worked together. So combined about 4 to 5 years, I knew Cody professionally and as a friend.
Tell the court about Cody Amato. Just describe and tell tell the court what kind of person Cody was.
I'd say Cody was a great friend, an amazing colleague, dependable, reliable. He was the guy that if you were in an emergency or you had a trauma or you needed hands, you knew that he would be there to help you without even asking. He was a guy that was always there, and you could count on him. And I think that speaks to his character. I think the fact that he was only presumably missing for 3 hours, and we were so concerned that we called him. I mean, how many of us can say that?
Okay. And tell the court, this is my final question, tell the court the impact on your life and the hospital's community of Cody's loss.
So Cody was to the hospital, no matter what was going on. If it was a slow day, if it was a busy day, he was a guy that, again, whether you were the guy mopping the floor or you were the guy that was helping out, you know, all the way up to the surgeons and everything, everybody liked Cody. He was friendly in the hospital. You know, there's still days today where we're sitting around and we still say, you know, we miss Cody. We miss the positive attitude that he brought, the camaraderie that he brought to the OR and to anesthesia as a group. He's still missed today.
Okay. Thank you very much.
All right, thank you, sir. You can step down. All right. As to that statement, there isn't anything that the court sees that would be, at this point, prohibited. So as long as it's indicated as to that, the court will allow for that statement to be
Yes, Your Honor, if
stated.
we may just make a request, we understand the court's ruling. In the final instruction that Mr. Stone had mentioned, there is the language about victim impact statements.
Right.
We would request the court, prior to the witnesses taking the stand, if the court, it appears the court is going to allow this information in front of the jury, if the court were to do so, we would ask the court to read that paragraph of the victim impact statement language in the final instruction, just so that the jurors are aware that what they're going to hear cannot be considered as an aggravating factor.
Well, they're instructed on it in the final aspect. So their final instructions, before they go back there, they're being told that what to consider and what not to consider. So
Understood. It's just based on the nature of what we have in front of us, Your Honor, just because of the potential inflammatory nature of it, understood the court has made its ruling. We would just ask the court that the jurors just be made well aware that what they're going to hear is just not an aggravating factor.
Mr. Stone, any response?
Your Honor, as the court pointed out, the court's going to instruct the jury on that after all the evidence is presented. The defense can certainly argue that, and I'm going to tell them that. So it's going to be told to them, I presume the defense is going to say that at least 3 times.
This is the circumstances. You guys have the preliminary instructions that the court's going to read. Each of you have your opening statements that you can give. Your opening statements can inform them otherwise, but they're going to be informed in the final instructions at the end of the proceedings, and they're going to be told what of everything that they considered or what of everything they heard they could consider for whichever reasons or towards whatever aspect of their decision. So I'm not inclined to say it before they testify. I am inclined, of course, I'm going to have it at the end where it will be in the final instructions. In the meantime, what I'm going to do is we'll take just a short few-minute recess. I'd like you to make sure and speak with Ms. Sloan or Ms. Young, because
Yes.
I'd like to also make sure and have what Ms. Young is going to testify to prior to the jury coming forward.
Yes, Your Honor.
Okay? We're in recess. All right, Mr. Stone. Are you ready to proffer Ms. Young's testimony?
Yes. Yes.
All right. We could get Ms. Young in here then, please? You could come forward, raise your right hand, please.
You solemnly swear or affirm that testimony you're about to give will be the complete truth, so help me God.
I do.
Thank you.
You may proceed.
Thank you. Good morning, Ms. Young. How are you?
I'm fine, thank you.
First, tell us what your name is, please.
My name is Sloan Young.
Where do you live?
I live in Osceola County, Florida.
And tell the court, please, what do you do for an occupation?
I'm a licensed practical nurse at Orlando Regional Medical Center.
Now, did you know a person during his lifetime by the name of Cody Amato?
Yes, I did.
And tell the court, how did you know Cody? How long? Describe your relationship with him.
He was my coworker, he was my friend, and then the last couple of months of his life, we had quietly started to date.
How long did you know Cody?
I started working at Orlando Regional in May of 2017. So we met right when I started. He was just finishing CRNA school.
Tell the court about Cody. Describe what type of person Cody was.
Sorry. Cody was he was the best person. He was the guy that everybody went to if they needed cheering up or if they needed help medically. When people talk about that guy that everybody loves and loves to talk to and loves to see, that was Cody. Our friend and coworker, Carla, said it best. She said that he was the best part of everybody's day, and that was completely true. He was, and I know he's definitely the best part of mine.
And please tell the court, and this is my final question, tell the court the impact upon your life and the hospital community of Cody's loss.
It's been very difficult. I've been diagnosed with post-traumatic stress disorder from this entire situation. We talk in the operating room that the morale at work died with Cody because it's just not the same. There's like a heaviness that hangs over the air, and it's very difficult to know that he's not here. And it's very difficult not just for me, but for all of our coworkers at Orlando Regional who work in surgery and then who worked with him prior, before he was a nurse anesthetist. It's very difficult to comprehend that he was only 31 and all the things that he wanted to do. Just going back to Japan, which is a place he loved, buying his dream BMW. He'll never get to do any of those things again. And I personally, I hate that I'll never get to order Jimmy John's with him again because he loved Jimmy John's for some reason. And that I'll never get to hold his hand again. He'll never get to come to any of my graduations, and he'll never tell me how proud he was of me for going back to school and how he believed in me. And I know for our friends and coworkers, it's difficult because as milestones come, as our friends get married, have children, he won't be a part of it. And that's very difficult for all of us.
Thank you very much.
Thank you.
All right. But the court will allow both of those staying within that realm, both Mr. Sisko and Mr. Young and Ms. Young. Okay? All right.
Your Honor, if we just made
Okay.
a late objection just to satisfy the record. There was, Ms. Young mentioned something about someone named Carla saying something. While we understand that she can certainly testify to the hospital community's loss of Cody's specific statements from this Carla person who is not going to be called, we would object to. Second, she mentioned that she was diagnosed with, I'm not sure
PTSD.
what she said.
She said she was diagnosed from PTSD.
Yes, Your Honor. the victim impact statement must be restrained to the victim's uniqueness, Cody Amato's uniqueness as an individual, and the resultant loss, her diagnosis, Your Honor. We would object to that information as well, or that testimony as well.
Well, the victim impact statement encompasses the effect on the family or the friends of the victim and the community, the effect on them of the loss of the victim. And she described precisely how it affected her. She's been diagnosed with post-traumatic stress disorder. So that falls squarely within victim impact. It's an impact upon her. That's what it's called, victim impact evidence, Your Honor. With regard to the statement that she referenced, I point out that the statute specifically says that the rules of evidence don't apply, that hearsay is admissible in a penalty phase proceeding. So I would submit to the court that that's perfectly appropriate to describe the effect upon Sloan Young and the hospitals and the hospital community.
The one thing in regards to the statement, the court noted, she said that our friend Carlos said it best. He was the best part of everybody's day, and he was certainly the best part of mine, or the best part of mine. So essentially, her commenting on what somebody had said is best, even if she said somebody at work said it best, either way, she was adopting that statement. So, in the feeling of the statement. So in that sense, the court would deny it. As to the PTSD aspect, she's indicating she was diagnosed with PTSD as a result of this. And she's indicating that was specifically done as a result of this. I'm going to actually indicate that's excluded. But the other part can come in. Okay? All right. Otherwise, is Mr. Amato going to be the first up this morning?
I plan on calling him first, but I'm not sure if he's here yet. Do
He
we know?
is. He's in the back of the courtroom. All right. The preliminary instructions. Any disagreement as to how the preliminary instructions for the proceedings for capital cases before they're read?
I'm sorry.
The preliminary instructions, I want to make sure there was no disagreement as to the preliminary jury instructions.
There's not, Your Honor.
Okay. All right. All right. At this point,
Judge, we would, before we start, we would go ahead and invoke the rule.
okay.
I have indicated to the state that if it's okay with Your Honor, we would invoke the rule with the exception of Jason Amato, if he wanted to remain in the courtroom.
I believe the other witnesses are already outside the courtroom from what I can gather. So it's only Mr.
I have one witness that's still in the courtroom, Dr. Carpenter.
Okay. And I'm not aware of who Dr. Carpenter is, which, all right, okay. Then at this point, the court can, based upon the rule being invoked, Jason Amato would remain in the courtroom, and otherwise, the other witnesses then would be excluded. Okay. So Dr. Carpenter, you're going to have to step outside.
And, Your Honor, there is the question, the last time that we met, we had a hearing on this, I advised the court and counsel that there were some modifications that I made.
Right.
So I guess that we probably...
The modifications are for the final jury instructions, not for the current jury instructions. We were going to go over those during lunch. We had discussed that last time.
Thank you.
If you remember that.
Judge, the last thing, before we bring the jury in, I had mentioned to the court last Thursday our concerns over recent events that have occurred nationally with regards to the mass shootings and the emotions those things have brought up. And I had asked the court to consider allowing us to voir dire the jury on those issues before we started.
Based upon the circumstances, the court's going to inquire of the jury based upon what they viewed, or if they viewed any of the news and otherwise. Even, I understand what you're saying or asking in regards to the mass shootings, but there were mass shootings prior to that. I know that were discussed or could have been discussed during voir dire or otherwise. I'm not inclined at this time, but we'll see where their answers to their questions go.
Well, I understand, Your Honor, and I appreciate the court inquiring, but I would take issue with the fact that there have been mass shootings in the past. There's been nothing that has caused the level of fear that's going on now, where people are stampeding when they hear a motorcycle backfire or a sign fall over, or the most recent one, some crazy person jumping up in the middle of a mall and, people getting hurt. I mean, there is a level of fear in our society right now dealing with gun violence that we have not dealt with before, and it was not in existence at the time we did voir dire in this case. So I really think in order for my client to get a fair trial, that the jurors need to have an inquiry made as to whether or not recent events have affected their ability to be fair and impartial in the case.
Your objection is noted for the record, Mr. Leichel, and the court is going to deny the request. And the court's not even aware of anything that you just stated as well. So, but either way, the court understands the fact of whether they have the ability to be fair and impartial was adequately inquired prior to them becoming jurors. But I will inquire of them. Deputy Bradley, can you please go get the jury? You may be seated. All right. Members of the jury, I do want to ask you all some questions. First of all, prior to us starting, I appreciate your patience. Back there, we had some things to go over this morning that I didn't anticipate. Plus, I was also to qualify the juries for all the trials that are going to be going on in the courthouse, which also took some time as well this morning. First, I want to ask all of you, please, to inform the court, have any of you at this time watched any news within the last 10 days since the verdict was encountered, or since for the alternates, since at such time as you were excused until today? Okay, so no aspect of any news at all, and everyone has avoided the news in its entirety, including newspapers or any news on the television, is that correct? Yes. Correct. All right. Also, have any of you, in any aspect, had any contact with social media, whether it be Facebook, Snapchat, Twitter, anything of that nature? No. I'd like you to answer out loud. No. Okay. So everyone has avoided social media. They haven't had any notifications, kept their notifications turned off, and not responded to any type of aspect on social media or even looked at any aspect of social media. Is that correct? Yes. Correct. Okay. All right. So at this point, nobody has had any knowledge, spoken with anyone then, or have any knowledge concerning any aspects of the case other than what you heard at this trial. Is that correct? Correct. You haven't spoken to any coworkers, family members, acquaintances, anything, or had any conversations regarding this case with anyone? That's correct. Okay, and that was a bad question. Let me ask that again. Have any of you had any conversations with any family members, co-workers, friends, acquaintances at all about this case or with anyone? No. No. All right. So other than what you had learned during the course of this trial is the only information that you have to obtain about this case. Is that correct? Yes. Okay. All right. So I think that also establishes the aspects for everyone's concerns at this point. Now, members of the jury, you have found the defendant guilty of 3 counts of murder in the first degree. The punishment for this crime is either life imprisonment without the possibility of parole or death. The attorneys will now have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during this penalty phase of this trial. What lawyers say during opening statements is not evidence, and you are not to consider it as such. After the attorneys have had the opportunity to present their opening statements, the state and the defendant may present evidence relative to the nature of the crime and the defendant's character, background, or life. You are instructed that this evidence, along with the evidence that you heard during the guilt phase of this trial, is presented in order for you to determine, as you will be instructed, Number one, whether each aggravating factor is proven beyond a reasonable doubt. 2, whether the aggravating factors found to exist beyond a reasonable doubt are sufficient to justify the imposition of the death penalty. 3, whether mitigating circumstances are proven by the greater weight of the evidence. 4, whether the aggravating factors outweigh the mitigating circumstances. And 5, whether the defendant should be sentenced to life imprisonment without the possibility of parole or death. At the conclusion of the evidence and after argument of counsel, you will be instructed on the law that will guide your deliberations. An aggravating factor is a standard to guide the jury in making the choice between a verdict of life imprisonment without the possibility of parole or death. It is a statutorily enumerated circumstance that increases the gravity of a crime or the harm to a victim. You must unanimously agree that each aggravating factor was proven beyond a reasonable doubt before it may be considered by you in arriving at your final verdict. In order to consider the death penalty as a possible penalty, you must unanimously determine that at least one aggravating factor has been proven beyond a reasonable doubt. The state has the burden to prove each aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, if after carefully considering, comparing, and weighing all of the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the aggravating factor has not been proved beyond a reasonable doubt, and you must not consider it in providing your verdict upon the appropriate sentence to the court. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, conflicts in the evidence, or lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find that the aggravating factor does exist. Before moving on to the mitigating circumstances, you must determine that the aggravating factor or factors is or are sufficient to impose a sentence of death. If you do not unanimously agree that the aggravating factor or factors is or are sufficient to impose death, do not move on to consider the mitigating circumstances. Should you find the aggravating factors do exist to justify the imposition of a death penalty, it will then be your duty to determine whether the aggravating factors that you unanimously find to have been proven beyond a reasonable doubt outweigh the mitigating circumstances that you find to have been established. Unlike aggravating factors, you do not need to unanimously agree that a mitigating circumstance has been established. Rather, whether a mitigating circumstance has been established is an individual judgment by each juror. A mitigating circumstance is not limited to the facts surrounding the crime. It can be anything which might indicate that the death penalty is not appropriate for the defendant. In other words, a mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that reasonably may indicate that the death penalty is not an appropriate sentence in this case. A mitigating circumstance need not be proven beyond a reasonable doubt by the defendant. A mitigating circumstance need only be proven by the greater weight of the evidence, which means evidence that more likely than not tends to prove the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you may consider it established and give that evidence such weight as you determine it should receive in reaching your conclusion as to the sentence to be imposed.